Well, first of all, I just want to say thank you so much for allowing us this opportunity to come out and earn your vote. I am incredibly proud to have made it into the runoff. We had great candidates running for this position, and I'm really happy to be here standing in front of you to earn this, to earn your vote. I was thinking about this race, and as many of you may know, I'm the associate judge in the 247th Family Court. And I have been serving as an associate judge for 7 years now. I received my first appointment in 2007, and that was from Judge Frank Wren, who is now retired from the bench, and he is now serving as the General Counsel for the Catholic Archdiocese of Galveston, Houston. And then I received my next appointment from Judge Sherry Wydeen, and actually I served for her for a short period of time, and she's the presiding judge in the 309th Family Court. And then I started working for Judge Bonnie Helms. And Judge Helms is retiring after 20 years of service, and so this is an open bench. And you know, all of the races are unique in their own individual way. And I was thinking about, as we shift gears and go into the runoff, what makes this race unique? And I was thinking about the two candidates, and I was thinking that this race could probably be broken down into two key issues. And one of those issues would be qualifications for the job that we're asking you to elect us to. And then the other issue would be our conservative principles and values. And so I want to address the conservative principles and values issue. I first decided to take my public service to a higher level back in 2009. And I had a decision to make, and that was how to run. Was I going to run as a Republican, or was I going to run as a Democrat? And how I made that decision was by pulling out the platforms and reading them to see which platform I identified with the most. And when I read the platforms, I knew immediately that my principles and my values were aligned with the Republican platform. And that's why I'm here. And I have gotten active with the party. When I ran in 2010, I was not successful, but I did not pick up my marbles and go home. I rolled up my sleeves and I got involved. I joined a home club, Magic Circle Republican Women, and I was on that board for 2 years. And then I supported conservative causes, including actively campaigning against the president in 2012. And I did that by going to headquarters and making phone calls for the Romney-Ryan ticket. Shifting gear, and I want to say many of you have welcomed me to the party, and I'm so grateful to you for doing that. Shifting gears to the qualifications, I stand before you with 7 solid years of judicial service. I'm very proud of my record. Year in, year out, the lawyers who practice in front of us evaluate us, and I have a solid record of being a conservative jurist. So I love what I do, and I'm asking for your vote, so thank you.
Thank you very much, Angelina, and all of you for being out here today. I sincerely appreciate having the opportunity to participate in this forum. I'm very proud to have finished first in the primary election on March 4th, and I'm especially proud today to announce that my former opponent, Melanie Flowers, has endorsed me in my campaign for judge of the 247th District Court. She received nearly 30% of the vote, so I am very, very proud to have her support. Just a very brief synopsis of my background. I'm a family law attorney. I've handled hundreds of cases in Harris and surrounding counties in just about every area of family law. I am a second career attorney. Before beginning my law practice, I served as vice president of a national bank and credit union consultant company. In that capacity, it was my responsibility to take financial institutions, many of which were in a state of crisis, like Andrews Air Force Base Federal Credit Union, Fort Bliss Federal Credit Union, and dozens of others, and turn them around so that they could become effective and efficient organizations. I also have a teaching background. I taught 11th and 12th grade history and science. And I also spent a year up in rural South Dakota working with Native American families from the Lakota Sioux tribe who faced alcoholism, drug addiction, and really unthinkable poverty. So I have the experience of dealing with these issues in a family court setting as a litigator, but also real-world experience in dealing with those issues as well. Just 3 distinctions I want to draw between my very worthy opponent and myself. Number 1, I would like to focus on life experience. I think being married and having children is a very important life experience for me. That's going to help me personally in being a better family court judge. Having the real world experience of understanding the struggles and challenges that married couples face, and having that understanding of that very unique, indescribable bond between a parent and a child is going to be very helpful for me in making just and compassionate decisions as a family court judge. I'm a lifelong Republican. I have a 100% conservative voting record. I've never voted in a Democratic primary. I never voted for Obama. And I think there is a clear distinction there between us. I believe my opponent didn't vote Republican until she decided to run for judge in 2010. So there's a clear distinction there. Lastly, I want to mention that I think the constitutional rights of parents are being trampled upon in some respects in the 247th District Court, the court that we're running for. And one example of that I'd like to give you is we have this rule in that court where the judge says, if you don't file a certificate of proof that you've taken a parenting course, then you don't get to see your children. Now, is that the kind of system we want? We have a judge that basically says, you can have your constitutional rights and you can have your natural rights as a parent if you follow my rules. I don't have anything against parenting courses, and they're actually required under the local rules. What I have a problem with is a judge dictating to parents and punishing parents by depriving them of their constitutional rights. And I see the stop sign, and I'm stopping. Thank you. One of the main things that I want to do as a family district court judge is make sure that our CPS cases, that we have very clear boundaries, that we're not just simply rubber stamping what CPS wants. Because I found that oftentimes there are in some of our CPS cases, there are our family court judges too often are rubber stamping what CPS wants. I have a very personal experience where we tried, my wife and I, even though we have kids of our own, we were going to adopt through the state. We were told it's very unlikely you'll be able to adopt because you're a traditional family, and secondly, you referenced your faith in a questionnaire that we sent you. So I think we need to be careful that we're not rubber stamping decisions that are made to foster a far left agenda that wages war on the traditional family. So how would I handle the docket? My goal is to choose an associate judge for sure that has experience in dealing with CPS cases. It's not one of these things where I want to dump all of the CPS cases on the associate judge, but I certainly will want and need assistance from the associate judge in handling all of those cases, because there are many. Thank you.
Same question?
Yes.
I would handle my CPS docket. I'm very familiar with the issues involved in our Child Protective Service cases. Before taking the bench, a good portion of my practice was dedicated to representing children who had been abused and neglected by the ones that are supposed to love them the most, their parents. So this is something that's very near and dear to me. I would handle the CPS docket. One of the things that I want to point out that's really unique about the 247th is that we are the drug court for the family division. What we have found with our CPS cases is the majority of them are in CPS care, not because of the really bad stories that you see on television, but because of the issues that their parents have with drugs and or alcohol. And they are being emotionally neglected, educationally neglected. And so we have drug court that these parties can participate in. It's voluntary. The other 8 family courts can refer them to us. They come in on every Thursday afternoon, and we address the issues to try to break the cycle of addiction. And I welcome all of you to come down any Thursday afternoon to observe. Okay, 2 parts. So with the attorney ad litems, those are specific for Child Protective Service cases, and those are the cases where the government has moved in and taken the child into the state of Texas's care. I would want somebody who has experience, who has done CPS work before, somebody who comes up to me and asks me. There's a lot of talent in the family bar. Somebody who comes up and requests those types of cases, and I usually start them off on the shallow end, meaning that I appoint them as attorney ad litems to represent missing parents. And then if they do well with that and they want to continue doing the type of work, then I'll give them more cases. There's not a lot of money involved in these cases, so you really have to have a passion for this type of work because it can be tough. As far as the amicus work, those are a little different. Those are cases where it's a private matter and the parents are going through a divorce and they cannot agree on who's going to be the primary parent. On those cases, my policy has been and will continue to be if the parents request it. An amicus can be incredibly expensive, and so I don't push those on parties who can't afford it, so it would be basically those parties who request it.
My rule in certainly CPS cases will be to make appointments based on merit, qualifications, and best interest of children. Certainly not on who's given money to my campaign. The amicus appointments, I'm really happy you asked that question because I have raised this issue in this campaign. I think we need to be flexible as family court judges. I think oftentimes we apply a one-size-fits-all approach, and I think we need to certainly look at the means of the litigants that come before our courts. We have a huge number of indigent parties that come into our court system. They either have attorneys representing them pro bono, or they're pro se parties, and they simply can't afford thousands and thousands of dollars of fees in amicus appointments. Some of these cases need something like an amicus appointment, but we have a tool that I feel like is underused in our family court system. It's called a social study, and it can cost a party as little as $110. I've used it before. It's been extremely effective. They do full research, background check, and they make a full recommendation to the court. It's usually a 25 to 30 page report, and it saves the parties money, and we don't have to resort to having them have their cases dismissed because they can't pay the amicus. Thank you. Okay, I think I've already mentioned one of the changes I would make, and that's eliminating this rule, which I feel is unconstitutional, saying that you can't visit your kids if you don't file a certificate of completion on a parenting course. I think that's outrageous personally. I think it's clearly unconstitutional. I would end that. I would require parenting classes. It's required under the local rules. However, the sanction is not, I'm going to take away your constitutional rights. I don't think any judge has the authority to do that. Secondly, I would change the tone in that court. With all due respect, I feel like litigants are too often humiliated in that court. I've seen lawyers get humiliated in front of their clients. And one of the things that I'm calling attention to in this campaign is I'm not running to be a dictator of that court. We're there to be a servant. We're there to serve the lawyers. We're there to serve the litigants. And to open up the courtroom and make sure everyone has their day in court. So certainly I want to change the tone as well. Thank you.
Well, I don't know if it's Judge Helms running or me running. I want to make it very clear that Judge Helms has implemented the parenting class requirement, and she is my employer. And as my employer, I uphold the policies of my employer. Whether or not I agree with them or not is a tricky situation to run as an associate judge because you want to respect the person who has hired you, and I think everyone in this room can understand and appreciate that. One of the things that I would change is she and I do see the parenting classes very differently. I don't think that one size fits all. I don't think that it's appropriate in every circumstance. So that is definitely something that I would change. And as far as the tone, I'm very proud of my record of being a judge who treats everyone with dignity and respect. You can look at my bar poll records and you will see that I am the judge. There are two of us. Judge Helms hears cases in the main courtroom and I hear cases in the other courtroom. So I don't know what my opponent has experienced, but certainly if he's been in front of me, it's been with dignity and respect. I would just say that it's my honor and my privilege to serve. The things that would distinguish me would be number one, I'm ready to start on day one. And so that's going to be a smooth transition for the families and the litigants. And for you, it saves you thousands of tax dollars. And I say that because you've already invested in my judicial training. It is my privilege to have worked for 3 different Republican judges, and I do want to clarify, Judge Dean did not appoint me to the bench. I was on that bench when she got elected, and she trusted my judgment enough to allow me to stay and continue to serve. So I ask for your vote. Thank you.
Thank you very much again for the opportunity. I sincerely appreciate it. My friends, I feel like I'm uniquely qualified for this position. I not only have a background of litigation, where I've handled hundreds of family law cases, including appeals in the Texas Court of Appeals for the 13th District, and before the Texas Supreme Court, but I also have a very strong business and financial background. Why is that relevant? It's relevant not only from the standpoint of managing an efficient courtroom, but also from the standpoint of dealing with some of the most complex issues that we face in our family courts, and those are the financial issues. Secondly, I have a teaching background. I have a proven record of service of dealing with those very issues that we, in the real world, that we deal with in our family court. So thank you very much again. I'm honored to be here. Thank you for your time, and I humbly ask for your vote.